All right, hi everyone. So this is the AP Government Unit 7 outline, which covers three chapters, Chapter 14, 18, 19, which are the Judiciary, Civil Liberties, and Civil Rights. I'm just going to be covering Chapter 14. It's a pretty big chapter. Right, so Chapter 14 is the judiciary system. It starts with judicial review. That is the right of the federal court to declare laws and acts made by Congress or the executive branch unconstitutional and therefore void. This is kind of a big deal in the judicial branch. This power of judicial review is unusually powerful in the United States in comparison to other countries. So it's really effective check on the other two branches of government, and that's something great that the judicial branch has, because before this it didn't really have that big of a check of power on the other two branches. So it's really meant to check the other branches and not enlarge the power of the courts, but it really has. It gives them policy-making abilities, where before they were just implementing laws that already existed. Now that it's giving them the chance to make and create their own policies. And this all comes from Marbury v. Madison. So there's two different judiciary approaches. There's strict constructionist approach, which is that judges should act and cast their votes purely on what is stated or clearly implied in the Constitution, which is kind of a more traditional approach. And the newer approach is judicial activism, or the activist approach, which says that judges should find the underlying principles of the Constitution and apply them using the basis of moral or economic philosophy. And you're going to see judicial activism come up a lot. So the development of the federal courts, the purpose of the courts was originally to settle disputes between interacting parties, because judges were originally supposed to just find and apply existing laws, but we now know that because of judicial review and Marbury v. Madison, that's not the case anymore. Judicial activism changed this in that it brought up the idea that judges are responsible for the laws and not just their application. So the judicial system is really neutral. It's supposed to be the most neutral branch of them all, and that's because there isn't as much policy making, so people don't have as big of an agenda to implement their own ideas. It seems most worthy to hold the power of judicial review because it is so neutral, and it's said to have neither force nor will, but merely judgment. And in this way, it's considered the weakest of the branches because it doesn't really have a specific set of goals to accomplish in the way that the other two branches do. So there's many influences on the judicial branch and judges, but the power of the courts is shaped by the issues of the time. So current events really shape the agenda of the judicial branch. Some examples are national supremacy and slavery. So when the Supreme Court ruled that federal law is dominant over state law, that is national supremacy. Some examples of this are McCulloch v. Maryland, which was in 1819, so early on. And then the Necessary and Proper Clause and the Interstate Commerce Clause, saying that the national government can kind of do whatever is necessary and proper. And this is the elastic clause, which gives the national government some elasticity to do what they want. Also the Dred Scott case. So in the Dred Scott case, Chief Justice Roger B. Taney ruled that African Americans could not be citizens, and therefore the Missouri Compromise was unconstitutional. This largely discredited the court in the North and gave a lot more power to the Supreme Court. Government and the economy, this is a big one. So from the end of the Civil War to the early New Deal, which is a long, long time, the biggest issue for the Supreme Court was the regulation of the economy by states versus federal government. It was kind of a big decision to figure out who got what powers the states could have and what powers the federal government could have. So this kind of led to a strong attachment and enforcement of private property rights. So the inherent wishes of the Founding Fathers in the beginning of America were life, liberty, and property. This was something that the Founding Fathers wanted, something John Locke wanted, something Enlightenment wanted. So it decided that the 14th Amendment not only protected citizenship rights, but also a person's private property rights. So a person could be a firm, a corporation, a business, or an industry, as well as an individual, but this protected them and protected their property as well as their citizenship in America. So this is where judicial activism becomes a big new idea, and it's getting a lot of attention. Before, it was all about this constructionist idea, these very traditional ideas. And judicial activism, born in the 1880s and 90s, this was born as courts had to rule on like every bit of government regulation of economic industry. And this led to people realizing that judges just kind of have to decide what is reasonable and unreasonable regulation based on the 14th Amendment. So this is not even ruling that is specifically applied or stated. It's just kind of what they believe, which is what judicial activism really is. It's all about the morals and values of judges. And this leads to judges being picked based off their record and their morals and values and their political party. It kind of changes how judges are chosen based on this new idea of judicial activism. And this unreasonable and reasonable regulation, this idea that judges could really kind of decide for themselves what was right, is kind of the judicial branches and the judges' own necessary and proper clause. It gives them that elasticity that the necessary and proper clause gives them, specifically for judges to enforce what they think is best. So at this time, courts upheld that the 14th and 15th Amendments gave African Americans a very limited provisions. So separate but equal sort of thing. Segregation is okay, which kept some places from allowing blacks to vote. So think the grandfather clause and the poll taxes, all of the provisions that kept African Americans from voting during this time period. That gave them very limited provisions. And this was upheld by the 14th and 15th Amendments. And this was through the courts, government, and economy. So now there's an idea of government and political liberty. So after 1936, the courts basically stopped shooting down any real regulations on the economy. And this was because in 1936, we're kind of getting to the New Deal. The New Deal implements tons of new government-created programs to help the economy. It was just not even necessary for the court to shoot down any real regulations. The New Deal kind of implements new programs and kind of does it for them. And Chief Justice Earl Warren in 1953 was the most activist period yet. Right, so moving on to the structure of federal courts. There's kind of three main components to the structure of federal courts, and they all have very distinct differences, so they're quite easy to remember. The first one is the Supreme Court, and that's the one that is most recognizable. It's the highest court in the federal system, and it consists of 9 justices. Although this number has changed in the past and can still change, there's 9, and they meet in Washington, D.C. Basically what they do is they appeal jurisdiction, but it's kind of a mixture of both. They can appeal jurisdiction, and that is the majority of what they do, but there is a limited original jurisdiction in some areas. So they can see new jurisdiction, or they can appeal old jurisdiction that comes up through the courts. And this is most of the time what they do. But remember that the Supreme Court sees very, very few cases because they want to view cases that assist their agenda. So about 96% of the cases that they review or that they see or that they get are not even presented in the Supreme Court and don't become a Supreme Court case. Only around 4% do, and that's after a lot of appeals and a lot of work to get it up through the federal court system. So below the Supreme Court is Court of Appeal, which is a pretty self-explanatory name because it doesn't allow original jurisdiction. It's strictly appellate, so it's all appeals. It's an intermediate level in the federal system, so it's right in the middle. There's 12 regional circuit courts, including a D.C. circuit. But again, there's no original jurisdiction. It's strictly appellate. But below that, where you can get original jurisdiction into a court is a district court. There's a lot more of these. There's about 94 judicial districts in 50 states and territories. But there's no appeals. It's the lowest level of courts, and it's the lowest level in the federal system. And it's original jurisdiction over most cases, but there's no appeals. So there's only appeals in courts of appeals and in the Supreme Court. Right, moving on. So there's different types of courts. There's a constitutional court, and this is power that comes from Article 3 of the Constitution, and judges are given constitutional protection in a constitutional court. And these are district courts and courts of appeals. Legislative courts are set up by Congress for very special purposes, and the staff in legislative courts are not given constitutional protection. So what is constitutional protections? It's what is given to constitutional courts, and it's no firing if they have good behavior, if the staff has good behavior, and no salary reductions while they're in office. So you can only reduce a person's salary after their term has finished. Right, so selecting judges. Judges are nominated by the president and confirmed by the Senate. This happens a lot in other positions as well. So remember, ambassadors are nominated or chosen by the president and confirmed by the Senate. This is a very common process, and it's the exact same for judges. So the presidents will tend to nominate people from their own party. And why is this? Well, it's related to the behavior and voting of justices based on their party, facts of the case, lawyer arguments, precedent, etc. So it's logically more effective for a president to nominate a judge who agrees with their values and beliefs and standings on political, economic, or social issues. So it's quite a big deal when their seat opens up on the Supreme Court because it gives the president a lot of opportunities to appoint a Supreme Court judge who will vote based on what the president wants because they have very similar values. And this kind of guarantees that if a new seat opens up for a judge in the Supreme Court, it's like 99% likely that it'll be the same political party as the president. And the president gives senatorial courtesy. So the president notifies and gets the approval of senators from the state of their justice nominee. So how do they select judges? Well, one of the ways they do it is through the litmus test. And this is a test of ideological purity in selecting judges. So presidents are kind of often criticized for doing this and using this test to select judges with who align with their ideologies, but it's quite effective. So the courts are now involved in the making of policies with judicial review. The litmus test is increasingly more important in the selection of Supreme Court justices. And additionally, senatorial courtesy, so notifying a senator about the appointment of a Supreme Court justice, is kind of non-existent today. And that has a relation to the litmus test and the increasing importance of the litmus test. Okay. The jurisdiction of the federal courts. So, federal courts. We have a dual court system that is state and federal. But the Supreme Court has original jurisdiction in certain kinds of cases listed in Article 3 of the Constitution. So remember, we're talking about the Supreme Court. We said it's mostly appeal cases, and that is very true. But in some cases, the Supreme Court has original jurisdiction, and that power given to them, that's by Article 3 of the Constitution. So federal question cases are all cases arising under the Constitution, the laws of the U.S., and treaties. And diversity cases are cases involving citizens of different states. Right, so as we have dual court system, we also have dual sovereignty. So some cases can be heard in federal and state courts. Dual sovereignty doctrine states that state and federal authorities can prosecute the same person for the same conduct. And what this does is it helps prevent the guilty from getting off due to holding sympathies of one level of authorities. It matters only allowed to be tried in state courts can be appealed to the federal courts. So you can't go straight to a federal court, you have to go through state courts. And most cases that the Supreme Court hears begin in state courts, just because they work their way up from district courts to appeal courts to the Supreme Court if they make it. But the Supreme Court can overturn cases. Right, so the writ of certiorari, the Supreme Court gets to pick and choose what cases it wants to hear. And this has to do with how few cases get into the Supreme Court. Remember, we said that 96% really just don't. They kind of die, or they don't make it through the Court of Appeals up to the Supreme Court. The writ of certiorari was issued by the agreement of 4 justices, indication that the Supreme Court will hear the case. They try to reserve their time for issues involving great federal or constitutional questions. So, for example, gay marriage is a huge issue or controversy going on right now. So it makes sense to hear a case about gay marriage, but something that is not relevant today, or has already been discussed, is not going to be listened to as much as a case of more prevalence or relating to more current events for the Supreme Court. Supreme Court has such heavy workload now that a lot of law clerks have gotten an increase of power. They just have so much to do. So, getting to court, like we said, it's a difficult process. Cases getting to the Supreme Court is even harder. So getting your case heard, especially by the Supreme Court, can be exceedingly difficult and very expensive. So you can file for a form of potpourri, which is without funds and therefore don't have to pay. And interest groups can help pay bills if they see the case as supporting their cause. So a lot of times, cases will get supported by interest groups because they kind of root for their cause. Fee shifting. Fee shifting is if the defendant loses, a plaintiff can make them pay for the party's fees. And a party initiates a suit. And these two terms will come up a lot when talking about getting cases to court, so there's something to remember. Right, so standing is a legal entitlement to bring a case to court. It must be actual controversy, and it must have been harmed. And it has been made easier to acquire standing in more recent years. So getting a standing is difficult, but if a person is in danger of being harmed, it's much, much easier to get a standing. So, but it must be of actual controversy. Right. Sovereign immunity is citizens cannot sue the government without its consent. And class action suits. A class action suit is a case brought to court by a person on behalf of others in similar circumstances to their own. So, an example is Brown v. Board of Education. It can turn small cases into really large ones when the same small abuse is done to many people. So Brown v. Board of Education is a perfect example of this. Small cases all add up to equal one large case, and these class action suits are what a lot of times get to the Supreme Court. So the Supreme Court in action, what this is it talks about briefs, which is a document that shows facts of the case, lower court decisions, arguments for the lawyer's case, and precedent. So this is really important in the Supreme Court. It lays out what they're going to be talking about in the court. So there's specific types of briefs from parties not directly involved in a lawsuit, and these are called amicus curiae, and that's a brief from a party. And then there's per curiam opinion, and that's a short and unsigned explanation of the court's decision. So there are 3 kinds of opinions in court among justices, and these all have to do with the outcome of a certain case. So there's the opinion of the court, which reflects the majority's view. There's the concurring opinion, which is in agreement with the majority decision, but for different reasons. So the opinion of the court is what the majority wanted, and the concurring opinion basically reiterates that is what they wanted, but they'll give a different reason as to why they wanted it. And then the third one is the dissenting opinion, and this is the opinion of the losing side. And oftentimes this is the most interesting because it gives a very different perspective on what the court wanted. And especially if it's a very close tie, like it's 4-5, a dissenting opinion can be really important in looking at the case again. So the power of the federal courts. The federal courts, most of the time courts are just applying existing laws to controversy. That's kind of one of the biggest jobs of judges is finding and applying already existing laws. Now, because of judicial activism, they have a lot more power to influence policymaking. But most of the time, they're just applying existing laws to controversy and controversial issues that are happening now. Like we said before, the court is run by current events and what is happening in the country currently. They're going to take more interest in prevalent issues than in older issues that don't have as much meaning to the government or even to the people. So they have to be controversial laws now. So there's a lot of power to make policy. Policy is made by courts by interpretation of laws in the Constitution. Again, judicial activism allows the judges to be more active in policy making and focus less on just solely applying laws and more so about making them. And this has made the courts really powerful. So there's a stare decisis, and that's the principle of precedent. Use past decisions as a basis for new decisions. And then there's a political question, which is a matter that the Constitution left up to another branch of government to determine. And this does happen a lot, is if the Constitution left an issue up to another branch to decide. And that's a question that can only be answered by another branch. A remedy is a judicial order setting forth what must be done to correct a situation that a judge believes is wrong. So if they want to remedy a situation or a case that has already been decided, this is when dissenting opinion comes in. If it's, for example, a 4-5 case, what's important about that dissenting opinion is that it can reveal a lot of times information about the case that can change the court's outlook on that case. And that's when they can remedy the decision and possibly overturn. The courts, not Congress, decide what Congress means in its law. Again, they're applying the laws. They're interpreting them for themselves. This is less of a constructionist view. It's more progressive and modern to believe that judges rely mostly on judicial activism. So what are the views of judicial activism? Those for it argue that justices undo the wrongs of the past. We're a much more progressive country. We're less traditional now because of judicial activism in the courts. And because of this, a lot of times cases can be looked at again with a very different perspective because judges are now able to use their moral values and beliefs to influence change and lawmaking and how laws are implemented. But those against it argue that justices don't have enough knowledge in specific areas to be able to judge beyond its laws properly. Yes, they are judges, but some people argue, are they experts? And because sometimes they aren't experts on very specific cases, do they have the right or authority to make decisions based off their beliefs and values in these certain cases? Okay, legislation and the courts. So, laws must be sufficiently vague for courts to have power in interpreting them. Like we talked about earlier, we talked about the reasonable and unreasonable, the necessary and proper, if you will. So what can the courts interpret? A lot, because everything's very vague and so courts have the ability to interpret what they want to. And again, this all relates back to the idea of judicial activism. Everything's so vague, so they get to apply their values. The attitudes of judges heavily affect what they do. And because of this, relating what we went back to was presidents really need somebody who will be on their side, who has the same attitude as they do about policy making, about political, economic, and social issues because it's going to heavily affect what they do and how they implement laws. So moving on, what are the checks on judicial powers? So we've talked a lot about what kind of powers the judicial branch does have, but what kind of powers don't they have? And we're getting to the end here. So judiciary power. Judges have little power to enforce the decisions that they make. They must be carried out by other branches. Like the legislative and executive branch. So should the president make executive orders? Should the legislative write in laws and make policies and create change based on what the judges enforce, or based on what the decisions they make that they would like to be enforced, but they can't really enforce themselves. So the relationship between Congress and the courts. The Senate checks the courts by confirming justices and impeaching them. So yes, the president does choose the justices that they would like, but the Senate must confirm these justices. And in the same way, the Senate can impeach these justices if they are not on their good behavior. So a lot of times judges are protected by their if they have good behavior, but they can be impeached. Congress can alter the number of judges. Remember, the number of judges currently is 9, but that has changed and that can change. Congress can undo a Supreme Court decision interpreting the Constitution by amending a document. So Congress can say to the Supreme Court, no, we're going to not do that. So they can amend the Constitution, or they can amend a document used to make a decision and kind of change how the Supreme Court made that decision. Congress can repass a law that the courts have declared unconstitutional with a slight to major revision. So Congress can revise something and then decide they want to repass a law that the courts declared unconstitutional or void. And finally, Congress gets to decide jurisdiction of the lower courts and appeal it jurisdiction of the Supreme Court. So they can withdraw jurisdiction for cases that might conflict with its interests. So for the lower courts, the jurisdiction is always decided by Congress. Okay. Public opinion and the courts. So courts may be arguably less affected by public opinion than other branches of government due to not being elected by the people, but they are still aware of it and they're very influenced by it. So in comparison to the other branches of government, for the executive branch, the president is chosen by the people, and he speaks a lot of times to the people and for the people. So he is heavily influenced by what the people want, and he makes decisions based on the people and what they are interested in and what they need. And then the legislative branch makes policies based on what the people want. They write in legislation because of the things that the president asks them to do based on what the people want. But the courts, they're not appointed by the people, so they don't really have to make the people happy. They want to, they would like to, but it's not necessary. So a lot of times cases they bring up, if a decision is not appreciated or approved by the people, it doesn't bother them as much because they don't get reelected by the people, and the things of this nature from the people don't relate to them. They can see just some disastrous effects of ignoring public opinion in the past, like in the Dred Scott decision. So they do want to appease the people and listen to the people's needs because they are the Supreme Court, the highest court of the land, and other courts, like district courts and appeal courts, do still represent the people and are from a place of representing the people because they listen to the people and they make decisions from the people's needs. And because of this, they realize how horrible it would be if they just didn't listen to anyone. But at the same time, they make decisions for what they believe is best based on the interpretation of the Constitution and their own moral beliefs and values, and less upon what the people necessarily want. And that is the end of my section. So that was chapter 14, the judiciary, talking about how judges get appointed, the components of the courts, and how the courts relate to the people. But the next chapters are 18 and 19, which are civil liberties and civil rights. And those chapters will be organized in themes.